Your Honor, thank you for being here today and hearing the case Mays Street versus City of Truth. Defendant's attorney states the evidence obtained was in violation of the homeowner's constitutional rights, including the Fourth Amendment right against warrantless search and seizure. A brief view of the incident at 1:17 p.m., the fire department responded to a first alarm assignment. First In Company stated they had dense black smoke issuing from the eaves and the roof. First In Company forced entry and advanced an 1 3/4 inch to the seat of the fire located in the living room near the TV. Smoke conditions were the heaviest in the living area near the TV. During extinguishment of the fire, the homeowners returned and advised no occupants were located in the house. The fire was placed under control at this time. All equipment was placed back in service. During this time period, a first alarm assignment was transmitted. Companies responded to children trapped 3 blocks from the current location. The fire investigator had not arrived on scene prior to the engine company leaving. I arrived and began the investigation. The homeowners were not present at this time. I noticed evidence of personal items missing, and the house seemed staged with a broken TV located in the heaviest damaged area. I noted a melted device behind the TV and noticed a pour pattern behind the TV towards the kitchen. Samples were collected and law enforcement notified. Charges of arson were to be filed against the homeowner. The attorney of the homeowner stated that entry was made into the home without permission and all evidence collected must be suppressed due to the chain of custody. Evidence obtained violates the homeowner's constitutional rights and Fourth Amendment against warrantless search and seizure. Your Honor, the Fourth Amendment prohibits unreasonable search and seizure and recognizes Americans' rights of privacy. Extenuating circumstances allow investigators to enter a home without a search warrant. Once inside, the plain view doctrine allowing seizure of any evidence or contraband found in the investigation. I would like the court to reference NFPA 921, Guide for Fire and Explosive Investigation, reference Fire Pattern Section 63783, Physical Evidence Section 17.54, Collection of Evidence for Accelerant Testing, Appliance Section 2632, Fire Patterns. You'll notice here, this is where the engine company made entry into the living room. You'll notice in this picture right here, this is the behind the television. You'll notice the V pattern, the burn pattern up the wall. You'll notice in this picture the pour pattern from the living room into the kitchen area. The reason for entry was to investigate the cause of the fire. Even with the small lapse in time frame and the scene unsecure, it was well within the chain of custody for the investigation team to work. Common practice within the fire service is reasonable time for the investigation of the origin of the fire that is unknown. All evidence collected was done properly and within the parameters of the law. I ask that all evidence collected at the home and testing found to be admissible in the eyes of the court. Thank you for your time.